Hi everybody, and welcome to this webinar, Intellectual Property in Franchising, How to Protect Your Brand and Build Value. My name is Ryan Palmer. I'm a principal at Great Plant Moody in the Franchise and Distribution Group. I'm here with my colleague Jennifer Deborah, who chairs our IP and Technology Group. We work with franchisors on a daily basis, helping them resolve IP issues and to develop systems to protect the IP that make up their brands. Today's presentation is an outgrowth of our conversations that we have with clients and the themes that we see from them and our observations about franchising. Our presentation today is intended to be helpful in a general sense. Please don't make any decisions based on it without talking to your own lawyer, and keep in mind that this is not legal advice. If you do have questions for us, there's a chat feature. Look for the Send Questions Here link. If you send questions there, it'll show up on the right screen, and we'll be monitoring that throughout the presentation so that we can answer them as they come in. And we'll also save some time at the end for questions as well. Here's a quick roadmap of what we'll be talking about today. There are 4 types of intellectual property important to franchisors: trademarks, copyrights, patents, and trade secrets. Every franchisor has a trademark. These are the devices that protect goodwill and the favorable consumer recognition of your brand. Lots of franchisors have copyrights. This is what protects expression. Think of books and pictures and music. Patents. This is important to some franchisors. It protects inventions, designs, and software. And trade secrets. This is the confidential information that makes up your system. Think about recipes, secret sauces, and formulas. We'll start with trademarks and a definition of them so you know what we're talking about here as we go. A trademark is something that identifies goods or services as coming from a single source. So you always know a Big Mac always comes from McDonald's. You know that you are going to be protected from confusion, and you can protect your commercial interests. So the time and energy that you spend developing quality standards and brand standards, all of those can be reflected by the trademark, and you know that a competitor can't take that and try to trade off the goodwill that you've built up behind your mark. A trademark also can signal uniform quality. This isn't necessarily high quality, but uniform quality. So you always know something tastes like it tastes before. And as I mentioned at the outset, trademarks are the cornerstone of franchising. A franchise agreement is really just a license agreement with additional controls in it. So owners of a trademark that is well recognized are the ones who are going to attract business partners. They're franchisees who are all willing to make an investment in a brand and pay royalties to be part of the existing system. A trademark can be a lot of things. It's going to identify a source or an origin of a product or a service, and that can take the form of words, acronyms, slogans. We put a bunch of examples on our slide here. So if we think about words, certainly the word McDonald's is a trademark, the word Culver's is a trademark, the words batteries plus bulbs, a trademark. You see Dunkin' Donuts on the left. Acronyms and initialisms can also serve as trademarks. You see DQ in the left rail of the slide there. NBC, also a trademark that's an initialism. And slogans. I'm loving it, don't leave home without it, just do it, you're fired. Also a trademark that is a slogan. Design, shapes, and symbols. You see a couple examples in the top left and the lower left of the slide. You see the Shell logo and the Mitsubishi logo. When you're thinking about shapes, also the iPod shape with the rounded corners, the DQ shell, you see an example on the slide there. Colors, sounds, and smells can also function as trademarks. These are a lot rarer than the other types of trademarks, but Owens Corning owns the trademark for pink insulation. Certain smells, there are only about 10 of them in the US, but apparently when you walk into a Verizon store, the flowery musk scent that you experience is indeed a trademark of Verizon. Or if you're shopping for sandals in a flip-flop shop, apparently there's a coconut smell that you'll experience when you walk into those stores, and that is a trademark of the flip-flop shops. Sound elements can also function as trademarks. We talked about NBC earlier. Their chimes are a trademark. The 3 notes GEC in sequence. AOL's old You've Got Mail, also a sound that it functions as a trademark. And also 20th Century Fox owns a sound mark, which I would typically do an impression of, but I'm told this is being recorded and will live in internet infamy forever, so I'll just play it. That is the Homer Simpson signature line that functions as a trademark. Trade dress, also product configuration, product packaging, and store and restaurant design. So anything that's trade dress is distinctive and non-functional. Think about Mrs. Butterworth and the shape of that syrup bottle, the Coke bottle shape. The Fuddruckers mark. If you think about the inside of a Fuddruckers, the black and white tile on the exposed sides of beef back in the old days, that was all part of the trade dress associated with that brand. Taco Cabana, the festive eating atmosphere they describe with artifacts, bright colors, murals, bright awnings, and umbrellas, all part of the Taco Cabana trade dress. Exterior of White Castles, KFC restaurants, the Tiffany box you see an example of there in the top left, all examples of protectable trade dress.
So this is Jennifer. I'm going to talk a little bit about the distinctiveness spectrum on trademarks, and when you're selecting a mark, this is really important to think about whether you're a new franchise system looking at adopting a new mark or changing your mark as you expand into a franchise, or even an existing system that maybe you have some secondary or tertiary marks beyond your house mark. When you think of new marks and want to adopt new marks, we try and we want those marks to be strong. And so the distinctiveness spectrum is a way in trademark law that we think about the strength of a mark. And so there's sort of 5 different types of marks, and we'll go through them from strongest to weakest. And the important thing about a strong mark is you get more protection. The protection is broader. You can protect not just the goods and services you use it with or you have it registered with, but related goods or services, things within a natural zone of expansion, and even things that might be somewhat unrelated, but a consumer might think that they were connected. So the strongest kind of mark is a coined or fanciful mark. So this is a mark that you did not exist before. You make up the word. Exxon is a great example of that. Kodak. A lot of pharmaceutical marks are coined marks. And those are great marks because you have the broadest scope of protection. I mean, Exxon is for gasoline and gas station services, but if you wanted to produce a battery and call it Exxon, that probably would be too close. Even though those are not traditionally related industries, there's certainly, Exxon is such a distinctive mark that a consumer might think it was the ExxonMobil company making those batteries. So those are the strongest kinds of marks. A lot of times people don't want to use a coined or fanciful mark because it doesn't tell you anything about what they do, but that's where the strength comes from. So you can combine a coined or fanciful term with a descriptive word, like you see in the next type of mark, Caribou Coffee. So it could be Exxon gasoline. So it's gasoline because it's part of the mark, but the Exxon is very distinctive. Caribou Coffee did that. While not a coined word, it's an arbitrary word. That's the second strongest type of trademark. So it's a real word, but it has nothing to do with the goods and services you're offering. So Caribou are not in any way connected with coffee. They don't come from places that produce coffee. There is a history in the owner's story about why they chose Caribou, but it's a great mark for that reason. It's an easy to identify word to the consumer. When they hear it, they know how it's spelled, they know what you're saying. Apple is another one of the strongest arbitrary marks out there. Everyone knows what an apple is, but there's no connection between apples and computers. So, and then with Caribou, what they've done, obviously, is they combine their mark with coffee so that the mark is really Caribou Coffee. They also now have Caribou registered by itself, I believe, but they've always used it as Caribou Coffee so that, you're driving past a strip mall, if you've never seen Caribou before, they're not selling large mammals, they're selling coffee. And so that's where you can get a really strong mark but still have that descriptive element. The middle kind of marks, still strong, not as strong as the other kind, are suggestive marks. So these are marks where you need a little imagination, kind of a two-step reasoning process to figure out why the mark is related to the goods and services. It doesn't actually describe it, but it makes a connection in the consumer's mind. And that can be helpful when you're thinking about wanting to convey a certain thought to a consumer, a feeling about what you're doing, but you don't want it to be descriptive and not protectable. So I have some examples here of what I would consider suggestive marks. Comfort Keepers for home, in-home care. I mean, it has words that talk about taking care of someone and making them comfortable, but it doesn't really describe it. Pillar to Post for home inspections sort of suggests something about a house, but doesn't, and the thoroughness with which they'll inspect your home, Pillar to Post, but it has, a nice ring to it, and it doesn't really describe what they do. Planet Beach is a tanning franchise, and so they have this idea of a beach, which is suggestive of tanning, but then Planet is sort of arbitrary for any services. I mean, it's and so it has more of a suggestive element. So those are sort of in the middle of protection, and those are also good marks. As we go down the distinctiveness spectrum, we get to descriptive marks, and a lot of systems start out with descriptive marks, and a lot of people like descriptive marks because they describe what the goods and services are, and the consumer doesn't have to guess or try and figure it out. But the problem with these marks is that they're hard to register and they're hard to protect. Descriptive marks can acquire distinctiveness over time. So through long use, through a lot of advertising, you can get a registration and you can get some protection. The Great Steak and Potato Company has been around since 1982. That's a mark that over time people did come to associate that mark with a certain source of restaurant services, but it's not a great mark to kind of start out with. You'll also see a lot of marks that I think are a little more generic, like renovation professionals. They really describe exactly what the poor people are. I mean, anybody who does those kinds of services is arguably a renovation professional. And so those marks are very hard to get any protection on, and they're not words that you can stop your competitors from using. So I think the distinctiveness spectrum is helpful when you're thinking about marks and thinking about new names for things, to keep that in mind and try and get the strongest mark possible. As I mentioned before, the stronger the mark is, the broader the scope of protection is, the easier it'll be to enforce your rights against third parties, keep other people out of your space, and have more rights. It also, when you're selecting a mark, it's important to try and avoid infringing a third party's rights. So whenever you're selecting a mark, and a lot of you may have been through this process in your systems or in previous systems, but there's a clearance process we use where we search the register and we search common law users, and we try and figure out, are there third parties using similar marks with similar goods and services. And ideally, when you're adopting a new mark, it would be pretty clean from an infringement perspective, because you don't want to adopt a mark and spend a lot of money rolling it out only to be infringing another person's rights. The other important consideration when you're selecting a mark is it registerable? So if it's too weak on the distinctiveness spectrum, it might not be registerable, and federal registration is very important for franchise systems. In the U.S., we have common law rights for trademarks, so you don't need a federal registration to have rights. You have rights through use, no matter wherever you're using the mark. So the real advantages for federal registration is this nationwide priority of rights, so you get the right to expand your business nationwide and have those trademark rights. Under traditional common law trademark law, you could have a restaurant named Bojangles in Florida, and you could have one, a different party could have one in California, and that would be okay. Traditional trademark law would say that's fine, no problems there. One party has rights in Florida, one party has rights in California. As one of them starts to expand, right, either up the coast, across the country, wants to go to the other coast, that becomes a problem. But they can't stop each other from using that mark. By getting a federal registration, if you were first and you're the Bojangles in Florida, you are basically preserving those rights nationwide. And so as long nobody could open somebody opened a Bojangles later in California and you wanted to go into that area, you'd be able to stop them and make them stop using the mark. So that's a huge, a lot of businesses, especially franchise operations, don't have national coverage right away. They're building regionally and then expanding nationally, and so that federal registration and that nationwide priority of rights is very important to the system. The other big reason you need it in a franchise system is the state business opportunity laws. So Ryan, maybe you can talk about that just briefly.
Yeah, you can get an exemption from the BizOp laws in the states if you have a federal registration, because in a lot of cases you're going to be governed by the FTC rule, which would take care of any sort of BizOp compliance. So without that, you have a whole set of registrations that you have to go through in various states in order just to do business there, or to offer your franchise as a business opportunity in those states. So there's a real practical issue there, in addition to everything that we're hearing from Jennifer on just an ability to expand.
And then in terms of geographic limitations on trademark rights, they are geographic. So even if you had a federal registration in the U.S., that only gives you rights in the U.S. And every country in the world has its own trademark law and its own system. They are harmonized to a great degree, so the laws are very similar around the world, and the process to register a trademark is very similar around the world. But if you're considering international expansion, one of the first things you should be looking at is obtaining registrations in any countries where you might go into, preferably before you start talking to people, because you often see that in countries where you've maybe talked to potential franchisees but then don't move forward, they might register the mark. And you definitely can have situations where people pirate your system in other countries. And that can be allowed under trademark law. I mean, it sort of varies on the strength of your mark and the fame of your system. But trademark rights are geographic, so if you, and in most countries it's based on registration, not use. And so if they register the mark there first, that could be a problem for you later on. And then just on the benefits of federal registration, I wanted to mention that, I mean, the other benefits you get is this presumption of validity. It's helpful when you're enforcing your rights against someone to have a registration certificate to show them that you have these rights. You do get to use the circle R. If you have a mark that's not registered, you can use the TM symbol regardless of whether you have an application on file or not. The TM symbol is just a way of letting people know this is my trademark. And then after 5 years, you do get this incontestable status, where if there were a senior user out there, you wouldn't be able, they wouldn't be able to challenge your use.
And incontestable here, I think, is important to distinguish from the strength of a mark. So when we say something's incontestable, we don't necessarily mean it's a strong mark. We were talking about what's a strong mark before, and that means there aren't a lot of other people using a mark that's close to your mark. When we say incontestable, we really mean it's harder for someone to cancel or to challenge your mark. When something becomes incontestable, it can really only be canceled if they allege you obtained the mark based on fraud, or if the mark is entered into genericide, or you abandon the mark or stopped using it. We've been talking about U.S. trademark registration and the benefits of that. So how do you get an actual trademark registration? Well, you have to file either based on use or what's called a bona fide intention to use the mark in interstate commerce. So what we're talking about when we say interstate commerce is really you're not conducting a really hyper-local business. You have customers that come from across state lines, and it's commerce that the federal government has a right to regulate. So interstate commerce means you're gonna have commerce in outside of your home state or outside of your home market. If you're a restaurant, even a single restaurant is often deemed to be in interstate commerce. There have been some challenges to that in recent years, but for the most part, even if you have a single restaurant and you draw customers from across state lines, you are deemed to be in interstate commerce. So you file the application, and on the application you have to specify the goods or services that are going to be associated with your mark. If you're a restaurant company, you would claim restaurant services. If you have a bar element, you would add bar services. If you're a manufacturing company, you would describe those manufacturing services. If you have a product, you would name the product. If you're a franchisor, you would add a Class 35 registration for franchise services, because that's really a whole different type of services apart from your core business. You're offering these business opportunities, so you'd also file a trademark in your main mark to protect those types of services. You, of course, have to pay a fee to the U.S. Trademark Office, the Patent and Trademark Office. It ranges from $225 to $400 per class that you claim in the trademark, and the variation there just depends on how you have to describe your goods or services, and if it's a standard classification or if there's some free text that has to be written in, and then how you file your application. And there are ongoing maintenance obligations once your registration issues. Between years 5 and 6, you have to file an affidavit of continuing use, and then renewals at year 10 and every 10 years after that. And as long as you keep using a trademark, it can exist forever. And as long as you keep up with your maintenance obligations every 10 years, and you pay your fees every 10 years, that registration can exist forever. So there are lots of trademarks that have existed for a very long time. That's
maybe just worth noting when we talk about different types of intellectual property, that they have different terms. So patents have a limited term of like 20 years. Copyrights have a limited term of 75 or 95 years. Trademarks can go on forever, and there's a number of famous trademarks in this country that are more than 100 years old. And then trade secrets are similar. We'll touch on that later, but there's no limited term to a trade secret.
To keep your trademark rights, it is important to use them properly, and here's the slide where the lawyers will always clash with all of the creative people and the advertising agencies, because there'll be rules that the lawyers and in-house counsel will be trying to apply to trademarks. So you should not use trademarks as nouns or verbs. You shouldn't add any sort of plural or possessive or an ing ending to trademarks. You should use the trademarks as an adjective. So if you think about examples of this, It's not send the FedExes, it's send the packages via FedEx courier, or hand me a Kleenex tissue, not hand me a Kleenex. Can you copy this on the Xerox brand copier? You know, things like that sound really clunky in normal English, but are important to make sure that that mark is being used in a way that it doesn't enter genericide. Elevator, kerosene, escalator, cornflakes, yo-yo. There are lots of marks that used to exist. There are now these ghost trademarks that don't exist anymore, primarily because of improper usage. It's something that Google fights every day. They don't want you to say, let me Google that for you. They want you to talk about the Google search engine or the generic noun that would follow Google being used as an adjective. Use your trademark notices and use them consistently. We talked about the circle R that you use once you have a federal registration. If you have an unregistered mark, you would use a TM or an SM to show people that you're treating that as a trademark. And think about things like quality control and system standards. You want that experience as part of your mark to always be the same or consistent for a consumer, so that they know that your trademark stands for this and that it's going to reinforce your trademark each time they experience your product or your service. And then be careful about licensing and transfer of the marks. If there's someone using the mark other than you should make sure there's a license agreement in place to let that happen. In some cases, it's going to be a franchise agreement if it's a franchisee that's using that mark. And if you've actually transferred the marks, or you have an intercompany arrangement where you have an IP holding company and you want those marks to be owned by that company, just make sure you've actually transferred that and actually documented it. You have to treat it like an asset. There's a device to help you remember all this called the ACID test, A-C-I-D. So A stands for adjective, meaning use your trademarks as an adjective. C stands for consistent. You should be consistent. You shouldn't change the logo. You shouldn't change the colors. You shouldn't change the presentation of the trademark. The I stands for identification. Use the R, use the TM, and you should, I should mention here, you don't have to go overboard on this. It doesn't have to be every instance of it in a brochure, on a website, whenever you're, if your mark appears 15 times, you don't have to use that marking each time, but at least use it in the first instance and then be consistent about it. And then distinctiveness. The D in ACID is distinctive. Use all caps or use italics in running text or something to set that mark off so people know that you're treating it as a trademark. So ACID, A-C-I-D.
So I want to talk a little bit about enforcement of trademark rights. You do have an obligation as a trademark owner to enforce your rights and to not, if you allow other people to use the same mark with the same services, you can lose the rights that you have. So one thing you might want to do is police the marketplace. You don't have an obligation to police the marketplace, but it's something that a lot of companies like to do. So there's a couple different ways how you learn about infringements. You should consider thinking about a watch service. That's something that we do for a number of clients, where we have vendors who provide watches where they'll watch the USPTO database and business name listings and things like that, and be able to report to us when there's similar marks or the same mark filed, and we can look at whether that's potentially infringing and whether we should be taking action. A lot of infringements bubble up from your customers or your franchisees, where people alert you to things. I think when that does happen, it's important that you investigate it, that you figure out if it is infringement or not, and if it is infringement, think about taking action. You do run the risk of, if you know about things and don't take action, that you have a laches or waiver issue that could affect the strength of your trademark rights long term. So in stopping infringement, you don't need to act against everything, but you do need to act where it's most critical and could affect your business. And we do a lot of cease and desist letters to potential infringers. Like I said, we have a number of watch services that might alert us to applications being filed that are too similar to our clients' marks. And a lot of this is resolved without litigation. I mean, it's very common that you can resolve a potential infringement dispute in a pre-litigation manner without through cease and desist letters and a negotiated settlement. So you do see that a lot. But it is better to have an agreement. A lot of times we enter into coexistence agreements where we define, okay, you can use these rights, but they're sort of close to ours, so we want to have you contractually agree to certain restrictions. You won't use it with certain goods. You won't change the way it appears. You won't do anything that would make it more similar to us, things like that. So that can be a helpful way of enforcing your trademark rights. In a franchise system, there's always post-termination covenants for franchisees after termination and things they have to do. It's important that you follow up on those and you enforce those obligations that the now terminated franchisee has. You want to make sure they don't adopt similar marks. They might stop using your mark and then just start using something more similar to your mark. We've handled a number of cases where you are able to, you sort of have a better argument with a former franchisee than just a third party in terms of how close it has to be infringing, because obviously the consumers in that area have been used to that, approaching that franchisee's business thinking it's one business. If it starts using just a similar mark, they may just think it's the same source as the services were before.
And that's really the franchisor nightmare. If you have a franchisee that hasn't de-identified a space and it's a retail-based concept and your flag is still over the door and they're serving different product inside or they're selling different product inside, that's a real problem for the brand for all of the reasons that we've talked about leading up to this. You know, your system standards, your quality control, the consistent experience, all of that is gone.
Right, and so it's worth thinking about what are the trade dress elements or other things you want, you know, what does de-identification require? Because if there's really distinctive elements or if the signage is a very distinctive shape, for example, we have that with some clients where just painting over it and putting a new word, different word mark, isn't enough because the logo itself is such a distinctive shape that we think it still might create some confusion. So in which case, if that's your system, you need to think about the signage has to come down in total, you know, and then are there, I mean, typically it would include cups and things like that in a restaurant service, but if it's a trade dress issue with a tile, I mean, maybe they have to change the interior design elements as well.
Right.
So that's pretty much it for trademarks and trade dress. We're going to talk a little bit now about trade secrets. I did get a question about a POS system that I'm going to address later, so I do want people to know that questions are coming in. So with trade secrets, there's not a trademarks, copyrights, and patents are all specific types of intellectual property governed by federal law. Trade secrets are a little bit different. They're sort of a broader type of thing, and they can really be comprised of anything. It's really almost any information of any kind, in any form, as long as it meets these certain criteria. And so the information has to be actually secret. It has to be kept from people who could obtain economic value from it. You have to take reasonable measures to protect the secrecy, and then that economic value is derived from the secrecy. So a common example of a trade secret would be a customer list. Another one would be a formula. The Coke formula is the most famous trade secret. The KFC mix of herbs and spices is a recipe formula that's a trade secret. And so if you have things that are secret in your system, if you want them to get the protection of trade secret law, you have to take these reasonable measurements to maintain the secrecy. So as I mentioned, there's all different kinds of trade secrets. Recipes. Software can be a trade secret, so a lot of software programs, if you have proprietary software, whether it's your POS system or any other kind of proprietary software that's developed for your system, there's a couple different ways that software is protected. One way is through copyright. The actual source code of software is protected under copyright law, but source code is also protected by many companies as a trade secret. They don't share it. They keep it under lock and key. They restrict access to it. It's not given, the franchisees only have object code. There's all different ways with software where you restrict the access to that source code.
And it's probably worth here just highlighting that anything that's like copyright isn't a trade secret because it's publicly available. It's not protected. Right.
So, well, so source code can be protected by copyright law. You can protect it under trade secret copyright registration, where you block out the trade secret portions. I mean, typically with a copyright, we'll get to that, when you register a copyright, you have to provide it to the Copyright Office, and then it becomes potentially publicly available, and so then it wouldn't really be a trade secret. There is a way you can kind of provide less source code, limited sections, redact portions of it so that it's sort of protected under both. But I would say a lot of software companies don't register their software. Some do and do this trade secret protection under the copyright registration system. Some just choose to keep the source code restricted. Pricing lists, financial information, operational methods. I mean, franchise systems have all kinds of items like this, and your ops manual might be a trade secret. Your ops manual also could be protected under copyright in the sense that it's a textual work. It's like a book. But if you want to protect it as a trade secret, then you have to keep careful control over it. You should make sure you know how many copies exist. Everybody who gets access to it is under a confidentiality obligation. They know they're not allowed to share it or copy it. You insist on getting it back from terminated franchisees. And there's a lot of interesting trade secret cases where the biggest issue is really, did you protect it? Is it a trade secret? Not because it would have had independent value if you had kept it a secret, but did you actually keep it a secret? So there's a couple different ways trade secret is protected under the law. There's a Uniform Trade Secrets Act, which has been adopted by 48 of 50 states, and provided a fair degree of uniformity in state courts about how trade secrets were protected and claims you could make for misappropriation of trade secrets. Just recently, the federal government finally enacted a federal trade secret act that's called the Defend Trade Secrets Act, the DTSA. It's not clear that it's better, it's different. So, you know, we still, when we look at a trade secret claim, would consider whether the state law under the Uniform Trade Secrets Act and state court might be a better venue for a trade secret claim, or federal court. But all of a sudden we do have access to federal courts now. If you want all the benefits from the DTSA, it does require you to make some additional disclosures to your employees in your confidentiality agreements. So some companies are doing that. Some companies will do that in the future when they do new employee confidentiality agreements. It doesn't mean you don't have access to the DTSA. It's just to get all the benefits, you need some certain disclosures. And we have found that in many cases, the state court is still a great place to bring a trade secret claim. So going on to protection of trade secrets, like I said, the most important thing is that you take measures to protect the secret, to maintain its secrecy. That includes physical restrictions, like restricting access to your areas of your, whether it's a locked file drawer or it's your office requiring badges to get in and things like that, security cards. You won't be able to show that something's a trade secret if basically someone could have walked in and just taken it from your office. You should mark things confidential. You should have contractual restrictions with your employees, your vendors, your franchisees. Typically it's in the franchise agreement that they have certain confidentiality obligations, but then it's important that when you give them things you want to treat as trade secrets, you let them know this falls under that. This is a confidential thing, and that's where the marking can be helpful. There's a lot of trade secret cases where it all falls apart for the party owning the secrets, because it turns out you could go to their dumpster and find what they're claiming is a trade secret, copies of it just thrown away, not shredded. You know, that's just fatal to a trade secret claim. If you don't take the reasonable measures to protect it, you won't win on a trade secret claim. So the last thing to mention about trade secrets is sort of, where are these helpful? I mean, as I mentioned before, there's unlimited duration. If you keep it secret and you take those measures, that it can last forever. There's no limited term. There's no governmental filing. There's no registration of trade secrets. It's just something that you're claiming. It covers all kinds of things that aren't covered by IP law. You know, trademarks just protect brand names, basically. Copyrights protect certain types of original works. Patents protect a very limited kind of types of inventions. And so there's a whole bunch of things that people think are valuable and would like to protect that aren't protected by copyright, trademark, or patent. And that's where trade secret can be really powerful, is know-how or technical knowledge or how we do things or our system. And there's a lot of things like that in a franchise system, that it's like just our methods that don't meet one of those other things that can be protected by a trade secret law. And it's really up to a court to determine whether it was a trade secret or not. So it can be very broad. Ryan will talk next about copyrights.
And a reminder, we're watching questions, so as you have them, chat them to us on the Send Questions Here link. Copyrights are things that are familiar to most people. These are, in a legal sense, original works of authorship. So literary works, musical works, graphical works, dramatic works, pictorial works, operating manuals, standards manuals, advertising, all of those things can be protected by copyrights. A copyright, to be protectable, has to be what's called fixed in a tangible medium of expression. All this means is it has to be written down or recorded to a disk. It can't be an idea or a thought or something that isn't in some way recorded. And there also has to be a modicum of creativity. This doesn't mean it has to be high art or have great artistic merit. It really just means that it has to have been independently developed by the author and not copied from something else that already exists. Here are some of the examples of things we were talking about. So advertisements, manuals, software, as we were just talking about in the context of trade secrets, can also be protected by copyright. Pictorial, graphical, and sculptural works. This is commonly art and photography, so the pictures of your products protected by copyright. Audiovisual works, your commercials, your YouTube videos, and then of course musical works as well. When you have a copyright, you have 5 exclusive rights. You get the exclusive right to reproduce that copyrighted work, to prepare derivative works of that copyrighted work. So when we're saying derivative work here, this is a copyright term of art that would cover translations or slight modifications of a copyrighted work, so it would be based on the original work. You have the right to distribute and to sell it for the first time. You have the right to publicly perform the copyrighted work and the right to publicly display the copyrighted work. There's an exception there for visual art, but for the most part, you have those rights without exception. Ownership is tricky in copyright. It seems like it should be easy. I said at the outset that it's owned by the author or the creator of the work. That gets complicated when you apply it to a business environment. So in an employer-employee relationship, if you're acting in the scope of your employment and you create something, so over the last few weeks, we've been working on these slides. We both work for Great Plant Moody. We're employees of Great Plant Moody. Unfortunately for Jennifer and me, we don't own these slides. Our employer, Great Plant Moody, owns these slides, and it gets to do with it whatever it wants. If we were consultants of the firm and we weren't employees of the firm, and we didn't have a written agreement that assigned the copyrightable work to the firm, we would own it. And we could go off and do whatever we want with these slides, and as valuable as they are. So you have to think about this, though, in the context of your own business. This comes up with consultants, web designers, advertising and PR agencies. Anyone who is producing content for you who is not an employee of your business should be under some sort of work made for hire agreement. And this could be as part of another agreement. It could be part of the consulting agreement. It could be as part of even a confidentiality agreement or just a general independent contractor agreement. But without that written assignment, if the person is not an employee, you don't own that, even if you pay for it. So, we'll often hear that, oh, I paid for it, so I owned it. Well, you paid for it, so you have at least an implied license that allows you to use it. And that's usually the answer that people don't want. They want to own it, and you should own it if you're paying for it. So just make sure you take that additional step of getting the work made for hire agreement. Did you want to talk about registration, Jennifer? Sure.
So copyrights are protected when they're created. So the rights in copyright actually vest upon the creation of the work, and registration is not required. As soon as you capture it in that medium that Ryan described, you put pen to paper, it's not just an idea anymore, it's a recording, it's a text, it's something like that. The copyright's attached, and the author has those exclusive rights. However, there is a registration process, and it's easier and cheaper than the trademark registration process. It's kind of a simple online form. Well, it's not that simple, but somewhat convoluted online form at the U.S. Copyright Office. But the filing fee is like $45, not like $300, and there's not as much of an examination process or a back and forth. Kind of goes to the Copyright Office. Typically, they take 9 to 12 months to issue the copyright, and then the copyright is registered as of the day you filed. A lot of people don't, register all their copyrights. If you're a franchise system and you have every piece of advertising collateral you create is protected by copyright, your ops manual is protected by copyright.
Your
website is a copyrightable work. Every memo you're writing, right? Every textual bulletin you publish to your franchise system is a copyrightable work. Businesses don't register all those works. What they do register is things that they think are particularly at risk of being taken. Having a registered copyright can be helpful when you go to enforce your rights. So, for example, if you were a home care franchise system and you had a training booklet about how your services are to be delivered, and you're worried that somebody would take that to another system and use it, that could be copyright. If you were a home cleaning service and you had a particular 10-step process and you didn't want other people to basically take that. I've worked with a pest control system and registered some copyright things for them, where it gives us an additional weapon when we go to enforce to have that registration. And in fact, registration is a prerequisite for litigation. So you can't bring copyright infringement litigation without a registration. So it often happens that it's something that's not registered, and we have to do what's called expedited registration. It takes a couple weeks instead of 12 months in order to bring a lawsuit. And that can be done. The disadvantage of doing it at that time is you don't get the benefits of having registered it before the infringement. So if you think it's something that's at risk of being infringed, it's an easy process to just register it ahead of time. And then you have this benefit under the copyright law that you could get statutory damages. If the damages are hard to measure, that might provide additional monetary relief. And then, more importantly, arguably, you can get your attorney's fees. So all the money you're spending to enforce your copyrights, you can get back if you win in the litigation. So think about your materials and whether there's something that might be worth copyrighting. You do see copyright notices on a lot of things, and although it's not required under the law to have a copyright notice, it is often recommended because it's a way of communicating to people, I consider this proprietary. Don't just run off with this. I think it's mine. I think if, I don't know that we have a copyright notice on our slides, but
I was just thinking we don't.
We don't, but if we had, I think it is the kind of thing where you might think, oh, am I allowed to forward this to somebody else? Would they mind? You know, it kind of just creates that. A lot of copyright infringement is inadvertent. People are not trying to be nefarious. They just don't realize. We don't mind if you share our slides, so go ahead.
We don't own the slides anyhow.
That's right. But that's a simple copyright notice. It's the C in a circle or the word copyright, the year of first publication, and then the name of the copyright owner, which as you can see is our firm and not Ryan and I. Another thing is sometimes recommended is a restrictive legend. Again, not at all required, but a restrictive legend is just taking the same idea of educating the reader that this is something you consider yours and they're not supposed to do something with it. So sometimes it's something as simple as this material may not be distributed or reproduced without permission. I mean, that is really just true under copyright law for anything that you see, but a lot of people don't know it. So putting that there is just a way of letting them know before when they're at the photocopy machine and they see that, they think, oh, should I be doing this?
And it certainly guards against the defense of unintentional infringement. If someone says, well, gee, I didn't even think that it would be a problem for me to do this. If you have a notice or a restrictive legend, it's pretty difficult for someone to argue that with a straight face.
Yeah, and these legends can be the kinds of things in a franchise system where, again, you have your franchisee, you have their employees, you have less control over everybody. It's just a way of saying, like, this is confident, you might have a restrictive legend that says this is confidential information, this is not to be shared outside the system, this can only be accessed by this and this person, I mean, it could take any form. And again, there's no legal requirement for it, it's really to help prevent infringement from occurring, to try and stop it proactively.
Or if you're treating it as a trade secret to help maintain that protection.
Exactly. So then with copyright infringement, that does happen. A copyright infringement is really when someone has violated one of those exclusive rights of copyright, the right to reproduce, distribute, make derivative works. You have to show that there was copying versus an independent creation, and you can show an inference of copying if there was substantial similarity between the two works and they had access to the first work. Intent is not really relevant, and there is a lot of copyright infringement that goes on where people did not intend to do it, but that doesn't really matter. A couple places I see this come up in franchise systems where they're on the other side of it, potentially infringing a third-party copyright, is in the music licensing area. So many of you know that there's 3 major music licensing houses in the U.S. There's different ones abroad if you open locations in other countries, BMI, CSAC, and ASCAP. And you have to have the right to play music in your store location, and they enforce those and they go around and they get licenses, and so that there's often places we see clients who are contacted because they did not have the right licensing in place from all those music licensing organizations. Another place we're seeing this more and more is use of photographs or other material from the internet. A lot of people and a lot of your employees don't know that just because something's on the internet doesn't mean it's public domain. Because you can cut and paste a photograph doesn't mean you should. I think the safest assumption is that everything is protected by copyright and you can't use anything unless you create it yourself or you get permission or authorization. And artists are getting better at having watermarks and digital watermarks in their photographs that are on the internet, and they can find when you've posted it in some obscure place on some blog, part of your website. And then there's law firms now who are very active in doing these cases for very, in kind of a cookie cutter way, and they come after, and in almost all cases the infringement truly did occur. You used a photograph because some employee or somebody took this photograph, didn't get it from a free stock photography house, and there is infringement, and then all we can do is try and limit the amount of damages you pay. But you will pay damages. There was an infringement, and it's often, several hundred to thousands of dollars or more when you could have just licensed for free some stock photography from the proper place. So it's really something you should be educating everybody in your system about.
And just to circle back quickly to BMI, CSAC, and ASCAP, one common issue we see there is that an owner of a business assumes whatever cable package they've purchased or whatever music subscription service they have includes the commercial license to play whatever gets streamed to them or sent by satellite to them, and very often that's not the case. You have to make sure that you've tied off on all those requirements so that your service provider is aware of how many locations you have, in some cases how many speakers you have and what your square footage is, and all of those sorts of things to make sure that any license you have would actually cover your uses. There, by the way, is some examples, some additional examples of acronyms as trademarks.
Right. There are some questions coming on this topic, so I just want to go to those questions now. So someone had asked earlier about this proprietary POS system. So if you have a franchise system that created their own proprietary point-of-sale system software, and that it pulls customer data from all the franchisees, how is that protected under intellectual property law? And I think there's a couple things implicated. When you talk about proprietary software that's been coded, so there's source code that's arguably protected, that is protected by copyright, may or may not be registered depending on whether you want to seek registration for the source code, and if you want to deposit that material potentially redacted with the Copyright Office, is protected under copyright law just when it's created. So, another franchise system can't just steal that source code and cut and paste from it and create a similarly functioning piece of software. The customer data is arguably a trade secret, and so your franchise agreement will normally cover who has rights to customer data, who has rights after termination, things like that. Do you want to comment on that?
Yeah, it'll very often be the property of the franchisor, or at least according to the franchise agreement, would be the property of the franchisor, and it would be, it depends how it's stored in terms of how it's protected, but that's really a creature of contract between the franchisor and the franchisee in terms of who owns that and how it's protected.
And if the franchisor wanted to take the position that that customer data is a trade secret, it has to be taking those reasonable measures in terms of how they're storing it and restricting access to it, and what contractual obligations they put on the franchisee and its employees to not disclose that. So someone else also asked about whether copyright should be protected under copyright law or as a trade secret, whether software should be done like that, or ops manuals or other confidential information. I would say that a lot of companies don't protect trade secrets through copyright law, that even if you could, you're sort of choosing. So just like with software, if you had an ops manual, you typically would choose not to protect that under copyright law. You'd want to protect it as a trade secret. And true?
I do, and it's because of the deposit requirement with the copyright. If you're treating your brand standards manual, your operations manual as confidential material, it's inconsistent then to have a copyright claim as part of that, because by doing that you're really showing that you're not treating it as confidential.
Right. Yeah. So yeah, when you get a copyright registration, it does risk being disclosed. You have to deposit 2 copies with the Library of Congress. They can choose whether or not to make those public or not. Some of them they throw away, some of them they keep on file, some of them they make publicly available. So you do have to sort of treat it as it's not really a trade secret unless if you seek copyright registration. With software programs, there is a specific deposit requirement where you're allowed to submit smaller numbers of pages or redact material from the software program, the trade secret parts of it.
And it's just a lot easier now to protect manuals and other kind of system-type information than it used to be in the days of the 3-ring binders when each location had one and a master copy was maintained. Now it's usually done through internet or some sort of electronic access system where you can track who has access to it, and you can restrict copying and printing, and you can take other kind of electronic measures to protect the trade secret nature of that product.
Someone also asked a question, if you take a photograph, could it be included in a copyrighted book if there were disclaimers from the people in the photograph? So I think the question is, yes, when you take a photograph, you own it. So this comes up in franchise systems as well. Like there should probably be guidelines for your franchisees if they take pictures at their locations, you know, who has the rights to use those, whether the system, the franchisor does as well. But I think the question is really about the release aspect of it, which we haven't really touched on, but there's privacy rights, which are different from intellectual property rights for the people whose name or likeness appears or photograph appears in the picture, and you should be getting releases from customers or anybody else who's identifiable in a picture. So someone's asking on Ops Manual, would you put a copyright notice on it if you treat it as a trade secret? I would put a copyright notice on it because it is protected under copyright law. It's just that you wouldn't register it in advance.
Right.
You know, and if you had somebody who did make a copy of it, they will have violated. Let me just start at the beginning. You have an Ops Manual. You have a copyright notice on it. You treat it as a trade secret. You restrict access to it. You have numbered versions. You keep track of them. Everybody's under confidentiality agreement. A terminated franchisee makes a unauthorized reproduction of it. They photocopy the whole thing, and then they go off and take it. You have both a copyright infringement claim against them and a trade secret infringement claim. You would write them a letter. You would allege both claims. If you had to pursue in litigation, you might choose to just pursue the trade secret claim so that you don't have to register the copyright, or you might try and pursue the copyright claim, but you're sort of down the road already, and you have that option.
Yeah, I think the mere fact you put the notice on there doesn't destroy your any sort of trade secret protection you have, but you do at some point come to a crossroads in how you want to enforce that.
Right. So I think the last thing we're going to talk about is just briefly talk about patents, and then we have a few minutes left for questions. So please do send in any other questions you have.
Yeah, patents are is the last piece of intellectual property that we wanted to cover today. So a patent, as you probably know, covers inventions. There are utility patents, there are design patents. So it would be something that covers and protects a new and useful process or a machine. It has to be something that isn't obvious or at least more than a trivial extension of existing machines or inventions. And then ultimately, when you prepare your patent application or your attorney prepares your patent application, it discloses for the world your invention in a way that will allow others to make and use that invention. You get the right to exclude them from doing that during the term of your patent, so during the 20-year term of your patent. But once that expires, the instructions are out there for all the world to see because your monopoly has expired. So your patent rights, you get the right to exclude someone from making, using, selling, or offering to sell your invention in the United States. So this is obviously only going to apply to the United States, and it's only going to apply during the term of your patent. So for most patents, that's going to be 20 years. I'd mentioned a design patent. That's something that is going to protect an ornamental element of something like furniture. Shoes often have design patents. A font can have a design patent. You'll see certain game boards that have patent notices on them. The ornamental, non-functional elements of those can be protected by a design patent, and those run 14 years. Once that patent expires, you don't have any protection anymore, and that's really the whole point of a patent, that it wants to encourage the development of new and useful products and inventions, but it also wants to encourage continual use of that. So like when a patent expires and on a pharmaceutical product, you see a real rush to market there for everyone to capture that, assuming that that's still something that's useful and consumers will buy because the code is out there and everyone knows how to make it. But you get a limited time period, so you get 2 decades to really exploit the value of that patent. And the last point I'll make about patents is these are rights to exclude other people from doing this. This doesn't give you the right to do this necessarily. So it's possible that another patent or some other right could preclude you or at least restrict you from really fully enjoying your patent. So that's where patent attorneys and assessment of prior art and existing patents is really important.
And maybe just one thing to note is patents only exist through registration.
Right.
All these other kinds of things, these rights can exist without formal registration. A patent is only something, it's a right the government grants you, a certain monopoly right. So until you have an issued patent, you don't have any rights.
Right.
And they're also very expensive. So while, you know, the filings, you know, a copyright is maybe a few $100s, a trademark is maybe a few $1,000s, a patent is like tens of thousands of dollars.
And when people complain about how long it takes to get a registration for a trademark, I always remind them that just be happy you're not doing a patent.
Right.
I mean, that's sort of the benchmark.
So we did have just a clarifying question back on that ops manual thing, that we do suggest that you would put a copyright notice, potentially some kind of restrictive legend, both on the copyright side, do not reproduce or distribute, but that also serves sort of trade secret protection. So it might be additional language that says confidential information. I mean, there's all kinds of different wording you could use for both of those purposes. That for ops manuals or other kinds of confidential material in your systems, you would do both, but you just wouldn't register the copyright if you think it's a trade secret. So I think that's all we have for questions. Nothing else has come in. There was a request for Ryan to actually do the Homer Simpson impression, but I think he's trying to avoid that.
I appreciate very much the request, and I'm going to deny it.
Right. So thank you, everyone, for joining us. And if you have any questions, please feel free to follow up with either of us individually.
Thanks, everybody.
Oh, just one last clarification. Someone asked about emailing the slides. We will be emailing the slides around, and I think this was recorded, and that will be presented as well. Thanks, everyone.